Do civil rights have constitutional limits? With the very recent announcement by President Barack Obama that he supports the idea of gay marriage, I began to think about whether civil rights do indeed have limits. Now, this is not the easiest subject to write about, as I am an African American male who knows about this nation's sordid history as it concerns its treatment of African Americans and other minorities. But yet I have to ask whether civil rights do indeed have limits. If they don't, I'm afraid that we are on a very slippery slope as it pertains to individuals and group rights. At what point will we have the political will to deny a group which perceives that it has been discriminated against what they want? I say this because with his announcement for support of gay marriage, has President Obama cracked open the door for more groups to push for what they perceive to be their constitutional rights? For example, what will hinder pedophiles from coming forward and claiming that they too, like the gay community, have been denied their constitutional rights to have free sexual access to the children of their choice? You say that the possibility of this is absurd, but to that I respond that if someone had told you not too long ago that the President of the United States would openly advocate for gay marriage, you would have shaken your head in disbelief. Now, I have absolutely no problems with civil rights which are based on God's natural law, or what God originally intended for mankind. For example, the 1967 Supreme Court decision in Loving versus Virginia, which outlawed laws which banned interracial marriage, is consistent with God's natural law, which in no way prohibits people marrying simply because of their racial composition. Or the 1954 Brown versus Board of Education decision, which outlawed de jure segregation in public schools, was in accordance with God's natural law. Certainly the decision which preceded it, Plessy versus Ferguson in 1896, which declared the doctrine of separate but equal to be the law of the land, was a direct contradiction of God's natural law. And why was this so? Because it denied the basic rights of association of African Americans simply because of the color of their skin, which is a God-ordained characteristic. But we then have to ask, is being gay according to God's natural law? There is no scriptural evidence that it is, but to the contrary, there is plenty of evidence that homosexuality is contrary to God's natural law, and thus we must question whether it is wise for us as a nation, which so depends on God's grace for our very sustenance, to give a collective nod to gay marriage. This is a very important point because marriage is the pillar of our society, and to declare that homosexual marriage is equivalent to heterosexual marriage is risky business, to say the least. Now, some will declare that because we are not a theocracy as was ancient Israel, we shouldn't worry about whether we are in alignment with the teachings of Holy Scriptures. Others argue that the so-called separation of church and state prohibit us from giving consideration to scriptural mandates when we form public policy. But to that I must respond that the separation of church and state is a political agreement that we have made to keep this nation from being ruled by any particular denomination or religion. But when God looks at us, he sees righteousness and unrighteousness, whether such dwells in the halls of Congress, the Supreme Court, the White House, the church, synagogue, mosque, temple, home, or local restaurant. So we must ask ourselves, as we did or should have immediately after the 1973 Roe v. Wade decision, which constitutionally sanctioned abortion on demand, do civil rights have constitutional limits? If not, I'm afraid that we're in for a very rocky ride. That's my opinion. What's yours?